You know, every time you click, post, or send a message, you're leaving a digital footprint. And in this huge online world, it can sometimes feel like our rights are, well, as virtual as the space itself. But that's not the case. There's actually a complex legal framework that's always evolving to protect us. So today, we're going to break that down. We'll look at the laws and the core principles that are designed to safeguard our identity, our privacy, and our freedom online.
Now, it's important to mention that this presentation is based on the works of Professor Vihar Kiskinov, so that's the solid academic foundation we'll be using as we explore these really critical concepts.
All right, so here's our roadmap for this discussion. First, we'll tackle the very concept of protection. Then we'll see how that actually works inside the legal system and who's responsible for it all. After that, we'll get into the specifics. What rights are actually protected? We'll also take a deep dive into some major EU regulations, and to wrap things up, we'll look ahead to what's next on the new digital frontier.
Okay, so let's start with the absolute basics. When we talk about being protected in the virtual world, what does that even mean?
Right, so online protection isn't just one thing. It's not just a single law or a court case, it's really a whole ecosystem. You need the legal rules, sure, but you also need the technology to back them up. You need social norms that support these ideas, and, just as importantly, you need us, the users, to be educated. For any of this to really work, all of these pieces have to fit together perfectly.
And here are those layers, broken down. Think of it like a structure with 5 essential pillars. You've got the legislation, the actual laws. Then you need enforcement, someone to make sure those laws are followed. Pillar 3 is technology, things like encryption that create technical safeguards. Then there's platform responsibility. The companies themselves have to play a part. And finally, there's education. If you pull out any one of those pillars, the whole thing starts to wobble.
Okay, so we've got a handle on the concept of protection. The next logical question is, where does this happen? I mean, where in the whole legal machine does this protection actually kick in?
And what's really interesting is that protection isn't just about what happens after something goes wrong. If you look at the 4 stages of legal regulation, of course, stage 1, making the laws, is critical. But our rights are most actively protected in 2 other places. Stage 2, which is just us, exercising our rights every day without any problems. And stage 4, when a dispute has to be resolved in court. So protection is both proactive, it's part of our normal online life, and reactive, for when we have to defend those rights.
All right, so we know what protection is and where it fits into the legal system. So whose job is it? Who is actually responsible for doing the protecting?
Well, the state is the big one, obviously, with its laws and its courts. But it's not the only player. Sometimes the state delegates authority to non-state groups, like organizations that manage copyrights. And then there's a power that every single one of us has, self-defense or self-help. Think about it. Every time you block someone who's harassing you or decide not to click on a sketchy link, you are actively protecting yourself. That's often our very first and fastest line of defense.
Okay, this brings us right to the heart of it all. Let's talk about the specific, tangible rights we're trying to protect in this digital age. What are they?
This quote right here from a huge German court case back in 2008 is so important. It basically said that your right to privacy isn't just about keeping your data secret. It's about the security of the actual devices that hold your data, your phone, your computer. The court recognized that your right to privacy has to include the integrity of the systems themselves.
But here's the thing. Laws just don't adapt at the same speed everywhere. Take identity theft, for example. In Italy, they have a really broad law against substitution of personality. This makes it pretty straightforward to go after someone for creating a fake social media account. But then you look at Spain. Their law is older and talks about usurpation of civil status, which is more like someone trying to legally take over your entire life. It's much harder to apply that to a temporary fake profile. This is a perfect example of the global challenge of keeping laws up to speed with technology.
So what about the platforms themselves? This is where you see a huge philosophical split between the US and the EU. In the United States, you have Section 230, which gives platforms really broad immunity for user content. But in the European Union, the Digital Services Act takes a different approach. It creates a system of conditional liability. This means platforms have to have clear, harmonized procedures for taking down illegal content, but also for protecting users' fundamental rights in the process. 2 very different ways of looking at the same problem.
And this leads us to a very modern question. Can a machine be an author? What happens to copyright when an AI creates something? Well, under current EU legal doctrine, the answer is a pretty clear no. And the reason is simple. Copyright is meant to protect an author's own intellectual creation. That implies a human personality, human creative choices. If a piece of content is generated entirely by an AI, it's missing that human touch, so it doesn't get copyright protection.
Speaking of the EU, that brings us neatly into our next section. Because when it comes to creating powerful legal frameworks for these incredibly complex digital issues, Europe has really taken the lead on the global stage.
And at the heart of the EU's whole approach is, of course, the GDPR. What it does is fundamentally shift the power over personal data back to you, the individual. It gives you a whole set of concrete rights. You have the right to access your data, the right to fix it if it's wrong, the right to have it deleted, that's the famous right to be forgotten, and so much more.
And that right to be forgotten? It didn't just materialize out of thin air. It actually came directly from a landmark court case, known as Google Spain. The EU's highest court had to weigh the public's right to information against an individual's right to privacy over time. They ultimately ruled that people have a right to get outdated or irrelevant info about them removed from search results. It's a fantastic example of how a single court case can lead to one of our most powerful privacy laws.
Now, the EU is taking that same kind of thoughtful approach to artificial intelligence with its new AI Act. It's built on a risk-based model. So some AI applications, like social scoring by governments, are just outright banned, prohibited. Then you have a high-risk category for things like AI in healthcare or law enforcement. Those aren't banned, but they're going to face incredibly strict rules on safety, oversight, and transparency.
And this leads to what might be one of the most important new rights in the AI Act, the right to an explanation. Article 86 says that if a high-risk AI system makes a major decision about you, say for a job application or a loan, you have the right to know why. You get an explanation of the logic it used. This is a direct shot at the black box problem, where these systems make decisions that nobody, not even their creators, can fully explain.
All right, let's wrap this up by looking to the future. Because technology, as we all know, never stops, and the law is in this constant race to keep up. So what are the next big battlegrounds? The next legal frontiers?
Well, for one, there's the emerging field of neuro-rights. This might sound like science fiction, but technologies like brain-computer interfaces are becoming real. And this creates a whole new challenge. How do we protect the ultimate final frontier of privacy, the human mind itself? We're talking about laws to protect our mental integrity, our free will, and our very thoughts from being manipulated.
Then, of course, there's the metaverse. This opens up a whole can of worms, legally speaking. What is the legal status of your avatar? If someone commits a crime against you in a virtual world, whose laws even apply? And how on earth do we make sure that fundamental EU values, like the rights in GDPR and the DSA, actually carry over into these new digital worlds?
And finally, something that's eventually going to affect every single one of us, our digital legacy. What happens to all your stuff online when you're gone? Your social media accounts, your photos, your data, even your crypto. Right now, the law is playing catch-up, and we still don't have clear answers for how to handle our digital inheritance.
And all of this brings us to one last really critical question. Because let's face it, the online world isn't just a tool we use anymore. It's a fundamental part of how we live, how we connect. It's part of our human experience. So as technology keeps accelerating at this incredible pace, is the law adapting fast enough to protect what makes us human? That is the challenge for all of us, and for the lawmakers in the years ahead.